Okay, so you know when you share like all that super personal stuff in therapy,
Mm-hmm.
you'd think it'd be like your own private vault, right?
Yeah.
Like just your thoughts and feelings locked away.
Right.
But, well, it turns out the whole who owns your therapy records thing,
Yeah.
it's way more twisty and turny than you'd expect.
Yeah.
Like there's legal stuff, ethical guidelines, the whole shebang.
Exactly. It's not as straightforward as it seems. This deep dive, we're going right into those complexities of client records in psychology.
Yeah.
We dug into a whole bunch of sources, legal statutes, those ethical codes that therapists follow,
Hmm.
trying to paint a clear picture, because this is something people often misunderstand.
Yeah, for sure. And it's not just about like deciphering legal jargon, right? It's about something way more basic,
Yeah.
like your rights as a client and the responsibilities that mental health professionals have,
Mm.
to protect that information. So whether you're currently in therapy, thinking about starting, or just kind of curious about how it all works behind the scenes, like
Yeah.
understanding these rules, super important,
Yeah.
really empowering, actually. So that's what we're doing today, demystifying it all, laying it out so you know exactly what's what.
Right.
So like, first things first, the big question, who owns these records?
Well, you'd think, right, like intuitively, that everything you talk about in therapy, that's yours.
Yeah.
And in a way, it is. You own the content, the actual stuff you share, your personal history, those insights.
Okay, so like the story itself is mine.
Precisely. But here's the thing. The physical records, whether that's a file folder or data on a computer, that
Oh.
usually belongs to the psychologist or the facility, it's like imagine you dictate a letter.
Okay.
The message is yours, but the pen and paper, someone else's.
Oh, I like that. Okay, so I own the message, therapist owns the medium. But that ownership, like, it's not a free-for-all, right? They can't just do whatever they want with my info.
No way. There are all these laws about confidentiality, privilege, mandatory reporting. This is where it gets really important.
Yeah.
These legal frameworks put some serious limits on how a psychologist can handle those physical records.
Right, because otherwise that'd be like a huge breach of trust.
Absolutely.
Totally. Okay, so aside from this whole ownership thing,
Mm-hmm.
why even keep these detailed records?
Right.
Seems like a lot of paperwork, honestly.
It is, but there are really important reasons. Like the American Psychological Association, they have their ethics code, right?
What?
Standard 601, it outlines 5 main reasons why. And the first one, this is probably the most relevant to you as a client, it's to help continue your care. So if you switch therapists or need to see someone else down the line.
Oh, that makes sense.
Yeah.
Having all that info from before would be super helpful because starting from scratch with a new therapist, not fun.
Not ideal at all. And then sometimes these records help with replicating research, but that's usually with anonymous data, so your privacy is protected.
Mm-hmm.
Third, institutions often have their own rules about keeping records. Then there's accurate billing, got to make sure everything's documented for financial stuff.
Right. Makes sense.
And lastly, this is a big one, these records help make sure therapists are following all the legal and ethical rules.
Gotcha. So it's not just red tape.
Yeah.
Like, there are good reasons for all this documentation, both for how therapy works and for keeping clients safe.
Exactly.
Speaking of keeping clients safe, let's talk privacy. Like, how do therapists actually keep this sensitive info confidential?
Oh, that's huge. Ethically, legally, a major concern. And the APA's ethics code, Standard 6.02, this one goes into detail about maintaining confidentiality and how to dispose of records properly.
Right.
Basically, psychologists have to keep things confidential through the whole process. From making the record to storing it, accessing it, transferring it, even destroying it. It doesn't matter if it's written on the computer, whatever.
So it's not just like locking a file cabinet, it's everything.
Exactly. And then there's Standard 6.02.
Oh.
This one says they got to use coding or other methods to de-identify clients if the info is going into a system that other people might be able to access without consent.
Like a research database or something where you'd use a number instead of a name.
Exactly. It's an extra layer of protection.
That's smart.
Yeah.
So what about, like, day-to-day? How do therapists actually keep things confidential in practice?
Well, you mentioned the locked file cabinet. That's basic for physical records. And for electronic ones, it's about strong passwords, encryption, all that.
Right.
And a really important thing is that all the staff, everyone in the practice, needs to be trained on confidentiality and know the procedures inside and out.
Makes sense. Everyone's got to be on the same page. But what about, like, the unexpected? Say a therapist gets sick or can't practice anymore.
That's a great point, and it's covered in Standard 6.02c. It says psychologists should have a plan for protecting those records if something like that happens. It could be an agreement with another therapist, someone they trust to handle things temporarily, or working with their professional association, they can help.
Hmm.
Some even have a professional will, like a regular will, but for their practice. It names someone to manage things, tells them where records are, all that.
Wow. I never even thought about that. But yeah, super important for making sure client info stays safe long term.
Absolutely.
Okay, so we talked about how long therapists have to keep these records.
Right.
They don't just hang on to them forever, do they?
No, definitely not. There are rules about that, both from California law and the APA's guidelines.
Okay.
So in California, it's the Business and Professions Code, Section 2919. It says licensed psychologists have to keep an adult client's records for at least 7 years after they're discharged from therapy.
7 years, wow. What about for people who are minors when they had therapy?
That's different. For minors, it's 7 years from the date they turn 18. So depending on their age, could be way longer than 7 years total.
Yeah, I see. That makes sense, though, given they might need those records later in life, legally or medically.
Right, exactly. And there are actually other California laws about this for different healthcare settings.
Oh,
So the health and safety one, Section 123145A, that one's about licensed outpatient clinics and places like that. They also got to keep records for at least 7 years post-discharge. And for unemancipated minors, it's at least 1 year after they turn 18, but never less than 7 years total.
so it seems like across the board in California, that 7-year minimum post-discharge is the standard.
Right, and with extra protection and longer time frames for minors' records.
Makes sense. What do the APA guidelines say about all this?
Their record-keeping guidelines, paragraph 7, it stresses that psychologists have got to be up to date on all the laws and regulations, federal, state, local, the whole 9 yards, and follow those rules for how long they keep records. But if there's no stricter law, they suggest keeping full records for 7 years after the last appointment for adults, or until 3 years after a minor becomes an adult, whichever's later.
So the APA says 3 years after a minor turns 18, but California law says 7 years after they turn 18. That's a pretty big difference.
Yeah, it is. And this is important. If there's ever a conflict, California law wins. It sets the minimum, like the absolute shortest time they can keep records. They can choose to keep them longer if they want, but they got to follow the law at least.
Gotcha.
It's a judgment call, really. They have to weigh the risks of having old info hanging around, maybe privacy risks, against the benefits of having a longer history available.
Okay, that makes sense. It's a balancing act.
Mm-hmm.
Now let's talk about how all this record keeping's changed in the digital age, with electronic health records and all that. How has that impacted retention rules specifically?
Yeah, EHRs are everywhere now. ETAA, that's the big federal law about health info privacy. They have rules for that, and California law does too. Specifically, the Health and Safety Code, Section 123149. That one's all about what healthcare providers have to do if they only use electronic systems, like if they don't have any paper records at all.
Interesting. So different rules apply if a practice is totally paperless.
Yeah.
What are some of those extra things they got to do?
Well, first off, they got to make sure those electronic records are secure and accurate, just as much as paper records would be.
Okay, that makes sense.
So they need an offsite backup system, just in case something happens and they lose data. And they need a way to electronically copy signed documents.
Mm-hmm.
Oh, and the system has to be set up so that once a record entry is finalized, it can't be changed or messed with.
So it's like built-in security features to prevent data loss and keep the record accurate over time.
Exactly.
So what about the original paper documents? Like if a practice goes fully electronic, can they just toss those out?
Yep. Once those paper records are stored electronically in a secure and accurate way, California law says they can be destroyed. But here's the thing. Once that happens, a printed copy of the electronic record becomes the official legal original. So if a client wants a copy, or if the state licensing board needs it, even for court cases, that printed version is what's used.
That's smart. So you get the efficiency of digital storage, but without losing the legal validity of the record.
Exactly.
Are there any cases where the original paper documents still have to be kept, even with an electronic system?
Yeah, sometimes. Like if a document just can't be stored electronically properly because of its format or something.
Yeah.
And also, Any provider using electronic records, they have to have super clear policies and procedures for everything,
Okay.
like how they're keeping things confidential, preventing unauthorized access, using electronic signatures, and making sure the system itself is maintained and secure.
Sounds like a lot of emphasis on really tight security and clear guidelines when you're dealing with electronic records.
For sure.
But do all the regular rules about patient access and confidentiality, do those still apply in this digital world?
Absolutely, they do. The law is very clear about that. It says nothing about using electronic records changes those existing rules.
Gotcha.
So patient access, how health info can be used and shared, confidentiality, how long content has to be kept, all those standards, they all still apply, whether the info's on paper or a computer.
So the technology might change, but those core principles about patient rights and protecting their data, those stay the same.
Exactly.
Okay, that was a really thorough rundown of how records are owned, maintained, stored, and the specifics of electronic systems.
Yeah.
Now let's get into something that I think is super important for anyone who's been in therapy or thinking about it. Client access.
Yeah.
Like, what are my rights when it comes to seeing and reviewing my own therapy records?
This is a big one. A lot of different laws play into this. There's IPAA, that's the federal privacy rule we talked about.
Right.
Then California has two laws. The Patient Access to Health Records Act, that's PAHRA, and the Confidentiality of Medical Information Act, CMIA. And then there's the APA Ethics Code, of course. In general, California law and HIPAA are pretty similar on this. A lot of times, California law either says the same thing as HIPAA or doesn't have a specific rule for something.
Okay.
So if you're following California law, you're usually good with HIPAA too.
Good to know they're generally on the same page. But I think you mentioned there are some cases where HIPAA actually overrides California law.
Right, especially when a healthcare provider is thinking about denying a client's request to see their records. HIPAA says a psychologist can deny access if they have a good reason to believe that letting the client see the records could put someone in danger, like actually endanger their life or safety.
Okay, so like a pretty serious situation.
Yeah, and HIPAA even has a process for the client to challenge that denial if they want.
So it's not just a blanket no.
Yep.
So how does California law compare to that, like in those situations where there's a potential for harm?
Yeah. Well, California has the Health and Safety Code. Section 123115B. It says a provider can deny access if there is a substantial risk of significant adverse or detrimental consequences to the patient if they saw their records.
Okay.
Now, that's kind of broad.
Yeah.
Could be interpreted more broadly than HIPAA's focus on, like, immediate danger.
Right, I see.
So usually, HIPAA's standard is stricter. It gives the patient more control over their info, and that usually applies to all records except psychotherapy notes.
So for most stuff, HIPAA's focus on the patient's right to access is what matters most.
Yep. But here's where it gets interesting and maybe surprising. There's one area where California law actually gives patients more power than HIPAA, and that's with psychotherapy notes.
Psychotherapy notes, are those different from like the regular notes a therapist takes during a session?
Yeah, they are. Psychotherapy notes are more like the therapist's personal notes.
Okay.
It's where they might jot down their own thoughts, theories about what's going on, stuff like that.
Yeah.
Separate from the more factual stuff like diagnoses, treatment plans. HIPAA is really protective of these notes. They say a therapist can totally refuse to let a client see them, and the client can't really do anything about it.
Wow. So under federal law, the therapist could just say no, and that's it.
Pretty much. But California law is different. It gives clients a bit more of a chance. So if a client asks to see their records, the psychologist has options.
Okay.
They can give the client the whole psychotherapy notes, they can give them a summary, or if there's a legal reason, they can say no.
So in this specific case, California actually gives clients more access than IPA. That's kind of wild.
It is.
So in this one area, really personal stuff, California is more on the patient side. What about the process, though? Like, how does someone in California officially request to see their records?
California's Health and Safety Code, Section 123138, it lays it all out.
Okay.
Basically, whether it's the adult patient themselves or a minor who can legally consent to their own health care or someone representing the patient, they got to submit a written request to the psychologist.
Makes sense.
And the psychologist can ask them to pay reasonable costs for finding the records and making copies.
Yeah, that seems fair, like covering administrative stuff.
Right.
Does HIPAA have similar rules about how you request access?
Yeah, HIPAA's cool with the written request too, as long as the psychologist told the client about that policy beforehand.
Good to know. So what if a client owes their therapist money? Can the therapist, like, refuse to give them their records until they pay?
That's a good question, and it's addressed directly in California law.
Okay.
Health and Safety Code, Section 1231NJ, it says straight up that healthcare providers can't withhold records or summaries just because there's a bill that hasn't been paid.
Oh, that's so important for clients to know. So even if there's a financial dispute, it doesn't affect their right to see their records.
Exactly.
What does the APA say about that, like in their ethical guidelines?
Their ethics code, Standard 6.03, kind of hints that it might be okay to withhold records for non-payment, but only in non-emergency situations. But remember, in California, the law we just talked about is what matters most. It trumps those ethical guidelines.
Right, so when there's a conflict between ethical guidelines and the actual law, the law wins.
Exactly.
So once a client's put in that formal request to see their records, are there specific timelines for the psychologist to respond?
Yes. California's Health and Safety Code, Sections 12312A and B, they're very clear about that.
Okay.
The provider has to let the client look at their records within 5 working days of getting that written request. And if the client wants copies, they have to get those within 15 days of the request.
15 days to get copies seems reasonable. What about summaries, though? Can the provider just give a summary instead of the whole record?
They can, but only under certain conditions. The Health and Safety Code, Section 12313A, says they can prepare a summary instead of giving the whole thing. But here's the catch. HIPAA steps in again, and it says the client has to agree beforehand to receive a summary.
So unless the client specifically says a summary's fine, they're entitled to the whole enchilada.
Right. Their full record.
What if they do agree to a summary? Is there a timeline for that?
Yes, if the client requests or agrees to a summary, Section 123130A says the provider has 10 working days to give it to him.
Okay.
But there's a little wiggle room. If the record's super long or the client was recently discharged from a facility, they can take a bit longer.
Okay.
But they got to tell the client why it's taking longer and give them a date when it'll be ready. And it can't be more than 30 days total from when the client asked.
So whether you want the full record or a summary, there are clear rules about how long it should take. Good to know.
Very helpful to know what to expect.
Wow, we really went deep on this one. I feel like I learned so much about how therapy records work, who owns what, and what rights clients have. For me, some of the biggest takeaways are that whole thing about content versus the physical record, how California actually gives more access to those personal therapist notes than HIPAA does, and that providers can't hold records hostage over unpaid bills.
Yeah, it's a lot more complex than people realize.
It really is.
Yeah.
And knowing all this stuff is so empowering for anyone in therapy or thinking about starting, like understanding your rights, knowing what your therapist is obligated to do. It just makes you feel more in control of the whole process.
Absolutely. It changes the whole dynamic.
It really does.
Mhm.
So after this deep dive, what are you thinking about? Like when it comes to your health info, not just in therapy, but everywhere.
Yeah.
Makes you wonder who has your data and what rights you have in all these different areas of your life, huh?
Yeah, it definitely gives you something to think about.
For sure.